Good morning and welcome to another edition of the Senate Committee on Commerce and Labor for the 81st Legislative Session. Madam Secretary, please call the roll.
Senator Hardy. Here. Senator Lang. Here. Senator Neal. Here. Senator Pickard. Here. Senator Scheibel. Here. Senator Settlemyre. Chair Spearman.
Here. So a couple housekeeping items, and I think by now everybody knows what the drill is. Make sure your phones are off, tablets are off, anything that's going to make a noise. Call your name or tell you to call home. Make sure that it's silent. And if those of you who wanted to say something or wanted to comment on this bill, you should have already registered. If you have not and you're under the sound of my voice, do so, and I guess they might try to get you in. Today, we have a hearing on Assembly Bill 61. This might be the last one. Nope, we got some more. Okay, we got some more. Some more coming out. But so we'll hear Assembly Bill 61. If you have bills that you're expecting to come out and you're concerned about them, make sure that you go to the legislative website, go to Commerce and Labor, and click on Participate. Do all that, put your name and address, your name and phone number in, and they will send you an email. Anyone who has an amendment for a bill that is being heard, if you have not talked to the sponsor, I'm not even going to entertain it. So you must talk to the sponsor first. I'm not the kind of person that messes with people's bills, so talk to the sponsor first, and if they say it's a go, then we're a go. So right now, is that everything? Yeah. Right now, let's open up the hearing on Assembly Bill 61. Proceed when you're ready.
Madam Chair, Vice Chair, thank you, members of the committee. My name is Mark Kruger. I am a Chief Deputy Attorney General with the Nevada Attorney General's Office. It's my pleasure to be here today to present AB 61. The intent of this bill is to amend consumer protection statutes, primarily to NRS Chapter 598, the Nevada Deceptive Trade Practices Act, for the benefit of individuals and businesses in this state. This bill, and I'm going to just keep it very high level, but this bill seeks to accomplish a few things. Seeks to establish a price gouging prohibition during the times of emergency. That's important to note that we worked with interested stakeholders and made concessions to ensure that provisions were limited in scope and duration. It only applies when the governor declares a state of emergency, and it's only applicable in the geographic area of that emergency. And finally, it has a fixed end date of 75 days. It also seeks to harmonize certain criminal penalties with that of general fraud or theft. It's important to note that we remained mindful of criminal justice reform and worked with interested stakeholders to align the penalties for theft under the Deceptive Trade Practices Act with that of general fraud or theft. There should be no statistical increase in the number of cases brought by the Attorney General's Office. It simply allows the Attorney General's Office to bring cases under the Deceptive Trade Practices Act for fraud or theft. It also seeks to revise provisions related to the administrative hearings and general administrative matters. These sections had no opposition, but a couple highlights are that it increases penalties for offenses against minors to mirror those against the elderly, and it ensures violations of the Data Privacy Act or violations of the Deceptive Trade Practices Act. It also seeks to modify the statute of limitations for certain violations of the Deceptive Trade Practices Act. It's also important to note here, we did not modify the statute of limitation for crimes or private right of actions. And finally, it seeks to adjust penalties for robocalling offenses. And again, it's important to note that we work with stakeholders and created a tiered structure for this. These are a high-level overview. I'm happy to answer any questions about specific provisions of the bill or go into any more detail that the committee wishes to hear.
Thank you, Mr. Kruger. Senator Hardy?
Thank you, Madam Chair. I see that there's a preclusion for charging more than the usual price. Are there any provisions in here that I haven't read yet, obviously, that preclude somebody from limiting the number of goods of a specific kind that can be sold to a given person so as to avoid the buying it out?
There are not.
Mr. Kruger, say your name.
Mark Kruger for the record.
Thank you.
Senator, there are no provisions for that particular piece of it. However,
So somebody could
Go
buy the whole thing out and then turn around and sell it on the black market, as it were, and this would get them who are reselling it.
Senator Mark Kruger, for the record, you're correct. There are no prohibition against buying every product on the shelf. There are also no prohibitions against a store limiting the number of items to sell. So a store would still retain that ability to do that in these times of emergency. However, you are also correct that if somebody did purchase all of the items and was permitted to do that, then they turned around and started selling them for more than the usual price, then this bill would apply to that individual reseller at that point in time, whether it's on the black market, as you say, or through a online store or merchant, or just in an open storefront.
Thank you, Madam Chair.
Senator Pickard and then Senator Settlemyre.
Thank you, Madam Chair. I'm looking at the sections on the robocalls and the like. Well, first, let me start with Section 1. We'll just take these in order. Is there an example of a Category E felony for similar types of conduct for deceptive trade practices?
Senator Mark Kruger, for the record, if I understand your question correctly, there would be, and there's a proposed amendment to align general theft provisions, deceptive trade violations, with general theft provisions. So I think what you're saying is, and maybe I'm off here, but what I'm hearing from you is you're asking if whether or not there's a similar provision. There should be if you pass the bill.
That's correct. Yeah, I'm trying to see, is this an anomaly in the law that we would make robocalls a felony?
Senator Mark Kruger, for the record, it's not an anomaly. It was just set as a misdemeanor prior. We're adding a tiered structure. And look, again, the focus on robocalling is to try, when we do have a person that we can ultimately find, we can then have some teeth in our law to be able to correct the behavior and bring an action to stop robocalling, because it has become egregious in the state of Nevada.
Sure, and I don't disagree. I hearken back to the 2017 session when Justice Hardesty came in and gave us a good long lecture about how the legislature tends to overpunish. We were talking specifically about the catch-all Category B felonies that seemed to make no sense. It's if we couldn't decide on what felony to make it, it was a Category B. Well, we haven't fallen into that trap, but for a business offense, particularly ones that simply cause mental or emotional anguish, to put somebody away for 4 years in a state prison seems to me to be pretty excessive. I'll be interested to see. I don't see the defense bar here today, but I'll be interested to see what they have to say. Let me move on. I'm going to skip over because Senator Hardy just asked one of my questions. I'm looking at the end of Section 3, the 75-day state of emergency. What happens if the state of emergency lasts more than 75 days? I seem to remember one in the recent past that went a little beyond that. Does that mean that this doesn't apply to the 76th day?
Senator Mark Kruger, for the record, going back to your last comment as well, I just wanted to make sure it was clear for the record that particular people who want to take advantage of robocalling aren't necessarily legitimate businesses. These are people who want to try to attempt using robocalling to defraud people. So I just want to make sure that's clear. So I think that helps quell some of your concerns there. As to your specific question in the other provision about the 75 days, we worked with interested stakeholders. And again, for the robocalling, we did work with interested stakeholders, including the defense bar, to accommodate concerns they had. But But we also work with interested stakeholders and came upon the number of 75 days because it's a good average that we noticed during the last pandemic, where the market, if you will, corrects, and the people who would take advantage of price gouging tend to fall off around that time frame. So it really isn't that important, critical first part of it. This gives the interested stakeholders some comfort, knowing that it doesn't continue on through a year or 2 year period, or however much time a certain particular individual emergency will last. It's also important to keep in mind that most emergencies are more limited in duration. You think of typically fire, earthquakes, other hazards, and they are also concentrated in a certain geographic area. And this bill seeks to make sure that we don't go outside of that geographic area that might be impacted for purposes of price gouging concerns.
Sure, and I appreciate that. I did notice that, and I think that's certainly appropriate. But the reason I asked that question, though, was because I recall 2 runs on paper goods, one immediately after the beginning of the pandemic, and then one as we hit the second spike. There was a second, although it wasn't as severe, there was a second run on paper goods. Would this bill then not, how does that trigger again if I'm trying to just think of the real world example of what happened. So on April 1st, when the run was really pronounced, we would have already started the 75-day period. How does this, or can this, come back into play after that 75 day? What I don't see in here is a secondary declaration or something that would allow the AG's office, say if it happened as it did, I think it was September, October timeframe. If, say, we had another run on paper goods, would the AG's office be unable to use this statute against somebody who decided to buy out the stock at Costco and then was selling it at 3 times the price?
Senator Mark Kruger, for the record, thank you for your question. And in coming up with concessions as well as the original draft of the bill, we provided the concession of 75 days based upon a peek back and a look at the complaints that we received. During that second run on paper, the supply was already starting to catch up. So it wasn't as severe, and we didn't see the complaints of price gouging that we saw within the initial period of the pandemic. So it's a good start. It's based upon data that we have, hard data, based upon complaints we received to determine whether or not the impacted area, and we believe that the concession meets the industry's concerns, but it also protects consumers. Certainly, it could be expanded to be bigger, but that first initial period in 75 days captures that, according to our complaints in this last particular pandemic, seems to be adequate.
All right.
You are correct. You can anticipate an emergency, and there could be something that could go on.
All right, and that's fine. I understand much of this legislative session has been deals that have happened outside the building, so I understand that we may not see all that you've accomplished, and I must say that it's too bad this wasn't in place at the time, because I think it would have curtailed some of that. I'm just thinking that the unforeseen thing is what happens if there's another run after the emergency has begun, and now we're left without a remedy. If there's no ability to start the clock again, if there's something that happens and we're still under the declared emergency. So if there's an amendment, I looked, I don't see an amendment online, but maybe I just didn't find it. But if there's an amendment, we might want to consider providing for a secondary trigger if it's deemed necessary. The governor could, as part of an ongoing set of emergency orders, if there's a need, we might want to consider that. My last question, let me see if I can find it. It had to do, I'm in section 17, sub 3. We're looking at loss of property, and then it's tiered, and now we're looking at category D, C, and B felonies. Can you explain why the tiering here on top of what we had before?
Absolutely, Senator. Mark Kruger for the record. That's the provision I was talking about where the bill now will seek, previously it was just a misdemeanor offense. That's all we had. Yet the theft or fraud that occurs under the Deceptive Trade Practices Act is akin to a theft, a general theft or fraud. So what we did was we wanted to mirror the penalty provision, which is tiered and tied to a loss amount as general theft or fraud. So instead of creating brand new cases that we would bring under the Deceptive Trade Practices Act, we simply say, okay, now we have the ability, depending upon the facts and circumstances of the offense, to bring those cases either under Deceptive Trade Practices Act or under general theft or fraud. Previously, we would always bring them under general theft or fraud. So that's exactly what we were getting at there.
All right, and so I think you just answered the question. I was going to ask, how does this square with Section 1? But you're saying this has created an option for the AG to go after one or the other in either case. Because in my head, as I was reading this morning, I had assumed that the Section 1 offense was for the robocalls and the Section 17 was for the fraud. I completely support the idea if you're taking $100,000 from somebody, that should be a Category B felony. I'm just not quite there on the Category E for a robocall. But what you're saying is this gives the AG an option to go after either offense as the AG believes is appropriate for the circumstance. Is that correct?
Mark Kruger for the record. Senator, I think you have it absolutely correct, but let me just make sure that we're both on the same mindset here. Section 1 amends 597, NRS Chapter 597. That is the robocalling offense. And that is tiered, and it is less of an offense for exactly the same reasons that you're talking about, but it actually gives some teeth to violations of robocalls for people who would like to use robocalls to perpetrate frauds or any other crimes against individuals in Nevada. The other section amends the penalty provision for Chapter 598, which is the Deceptive Trade Practices Act. So you're correct in that it aligns the theft with the general theft provisions and penalties in NRS.
All right. Well, thank you. Thank you for your responses. I think I better understand the bill. I'm still a little uncomfortable with a Category E felony for robocalling, but I certainly understand the impetus. And it's not going to, I don't think it'll keep me from supporting the bill. Thank you, Madam Chair.
Thank you. Senator Settlemyre, then Vice Chair.
Thank you, Madam Chair. I'm curious within the definitions of offense. I was wondering how that's determined. So if you have 3 separate customers that you've gouged, does that create the 3 offenses? Or also if it's 3 separate items, so you had 3 different things you bought from the person, or how is the term offense calculated in this type of discussion?
Senator Mark Kruger for the record. I think that you're speaking about the price gouging particular provision of it. And if you are, then I'm trying to find the exact provision.
Section 1A, it says for the first offense,
Oh,
for the second offense, for the third offense, and I'm asking, would that be 3 separate customers? Does that create 3 separate offenses, or does it have to be 3 separate fact scenarios? So they gouged you on widgets, then they gouged you on a car, so that created 2 separate offenses, or is it just literally 2 customers?
Yeah, and so Mark Kruger for the record, Senator. So Section 1 applies to the robocalls. So it would be offenses of robocalling. Now, what we envision with that is that the offense is that you perpetrated fraud against an individual using robocalling as a means to do so. And then the second offense would be you did it again after you've gotten punished after the first time. And then the third one would be you did it a third time. The price gouging goes in the dollar amount. So it's the amount of loss. So when we're talking about price gouging, we're talking about the provisions we just talked to Senator Pickard about, which is the tiered amount tied with general, kind of aligned in harmony with general fraud offenses. So it would be if you do the $100,000, you're going to be in the B felony. If you're, within $600, you're in misdemeanor, things like that.
Okay, I appreciate that. Within that explanation, provide some clarity, at least for the record, on those particular points. How many robocalls last year did the AG's office punish, period? I mean, how many telemarketers did they go after last year in total? Just out of curiosity, because I know there's a huge problem with this, so I'm just curious how many you guys went after.
Senator Mark Kruger for the record, and I appreciate that question because one of the problems with robocalls is that it's very difficult to find the person that's perpetrating it. So while we individually as a state haven't had the opportunity to go after an individual by ourselves, we have participated in multi-states and worked with other federal and other state partners to be able to bring some of these robocalls to justice. And in particular, we had a recent case that stopped quite a bit of calling and had a lot of injunctive relief on every effort. However, when the time comes, because the technology is getting there and we are working with state and federal partners to be able to identify these robocallers, we want to be prepared and ready so that we can bring these actions and have enough of a deterrent in this state so that it curbs at least some of this abhorrent practices.
So if the AG's office didn't prosecute any telemarketers, robocallers last year, how many have they prosecuted over the last 4 years?
Well, again, Senator Mark Kruger, for the record, the prosecution individually within the state hasn't had a lot of success and tracked, and I don't have an actual number for you because I haven't looked back at a peak of 4 years. But I can assure you that we have worked with other state partners to work together to do this, and the technology is coming. It is coming to be able to identify who's making these calls.
Okay, I'll get off the robocall then, and I'll go into the issue of the price gouging. I'm curious, it says the usual price for the good of service, and so does that go to the usual price for the good of the service prior to the declaration of the emergency?
Senator Mark Kruger, for the record, that's correct. And there is an actual outline in the bill that says we can look back to the peak of 30 days within the time frame. It's important to note here, what we did not want to do was punish or any way make it price gouging the supply chain. The supply chain in any state of emergency may have an increase in cost of getting the actual goods to the consumers. And we didn't want to make that a penalty. And that's what we ensured we did in this provision.
So where within that provision do you capture that? Because that's what I'm concerned with. I mean, because frankly, I'll go ahead and name names and I'll get in trouble, I'm sure, on the record, but do I get to go after Home Depot, Meeks Lumber, Lowe's, and everything for the cost of a sheet of plywood right now that's increased 235% in the last 5 to 6 months? I mean, that's just supply chain because of other things that's happened with the mills being shut down. But where within this bill do I see that is not going to be prosecutable? I mean, I look at farming. I've got John Deere parts that cost me $1,200 3 months ago, and now they're $2,400 on a turbo I just ordered. And they're claiming because, all the production that got seized in China and everything went bad. So I'm kind of curious, where within the bill do I find that part that explains that in that respect?
Senator Mark Kruger, for the record, and I understand your concern, and that was a concern of the industry when we had a lot of discussions with them, and it was something that we made sure was clear in the bill. So it doesn't specifically say supply chain, but the definition that you talked about is usual price. If it's usual price before, it doesn't mean that the usual price with the supply chain increase gets changed, right? It's still the usual price. So if the supply chain increases and you can show a supply chain increase, you are specifically exempted from that passing that increase along to consumers.
All right, I appreciate that. And you indicated, though, that it's clear in the bill. So could you just point to me where it's clear in the bill?
Senator Mark Kruger, for the record, it's in Section 3, and I will have to read the
Section
entire
3.3b1, it says usual price, but I'm saying, to me, that's not very clear. Because the usual price was a price prior to the pandemic or prior to the state of emergency. And we've seen lumber go up 237%. And a reasonable, explanation or just simple reading of it would kind of indicate to me that the price used to be much lower. And I appreciate we're establishing the record that will hopefully be able to be utilized by individuals, but I'm concerned because I really don't think it's that clear. So if for some reason amendments proffered, I'd love to try to find a way to make it clear. That's my concern.
We understand, Senator Mark Kruger, for the record. If you check Section 3C, D and E. It will lay it out for you, and I get it. We have to read them all together, but it attempts to make sure that that supply chain is untouched, so that it's not affected and prohibited by this provision. Only deliberate and willful, I should say, increases that really constitute what we all know as price gouging during the time of emergency.
So again, go to read C, D, and E, and just do me a favor, you don't have to answer it now. Read C, D, and E, and explain to me how that explains the concept that lumber's gone up 237% in the last 4 months. I can't read that into C, D, or E myself. That's not a seasonal fluctuation. That's not a contract price. That has nothing to do with normal markup. And that's my concern. Thank you.
Vice Chair Neal?
Thank you, Madam Chair. I just have one question on section 1, but I have a series of questions. So for the auto dialing, are you guys going to at least do some reporting? I think like IRS or FTC allows you to, if you can get like the name of the person or the company that calls you, you can at least put that number in and get it in a list. I mean, are you guys considering that at all? I know there's reporting in the bill, but this kind of allowing folks to say, like, when they get that call, they can put in the 1-800 or whatever number so that you guys can track those numbers. Is that a conversation?
Senator Mark Kruger, for the record, appreciate your question, because it is something that we are working with other states, and I've noticed that other states have had certain software and bills that allow that type of provision. It's something we've been discussing internally, as well as our work with other states, and in conjunction with the National Association of Attorneys General. Due to the pandemic, certain conferences that we were supposed to attend and really work with other stakeholders got delayed a little bit, pushed off, but we're back on track, and we're looking forward to this summer actually bringing a lot of other additional information and ideas forward. And we hope that, and we'll be considering that as an option.
Okay, thank you for that. And then in section 3, I had circled the calculations, which is in 3A, B, C, D. So how did you guys come up with those calculations to determine, because it's interesting, but I want to know how you guys came up with it, right? So we're kind of, I would say we're past the pandemic. So did you set these calculations based on actual activities that you had seen in the space to figure out your thresholds?
Senator Mark Kruger, for the record. Initially, we did look, attempted to look at the activities and complaints that we received to set these. Initially, we didn't have the structure. However, in discussions with stakeholders, it is pretty apparent that, you know, a percentage increase for a smaller amount, a smaller percentage increase isn't as significant an impact on a consumer as a larger increase is. Larger percentage amount. So we came and worked with group interested stakeholders and worked with us internally and came up with these as we thought would be a reasonable and fair way of setting it. There really wasn't a way to do it without setting some sort of percentage amount above the usual price to capture what really would be price gouging versus what would be normal markup.
And so my question in this same section, before I go to another section, so when you look in, it's the offers to sell, right? So you have the person who sells, rents, or offers to sell or rent any of the following goods or services, and then we scale down the bill. So when we talk about the offers to sell, talk to me about how these provisions work mechanically and trigger a penalty for an offer to sell? Because I think that's key, because an offer is not accepted, right? And so,
So, Senator Mark Kruger, for the record, and you bring up a good point. I will endeavor to try to answer this question as best I can, but we're in a position of trying to protect consumers. And in order to protect consumers from harm, sometimes in the space of price gouging, an offer to sell when somebody's in the middle of an emergency who is desperate for a good or services will inevitably end up paying for something anyway and consummating that contract, right? But that's what we're trying to do, is prohibit and make a deterrent for people to even go into that realm of offering and taking advantage of people who are in desperate situation to begin with. And that's the reason for the offer to sell language, in addition to the actual consummation.
so I understand that. I just wonder, since we've kind of had a chance to see behaviors, right? If we now can take a more calculated approach to what we've actually seen. It's broad, right? And so you sometimes, when we're trying to catch a big fish or several fish, we cast a broad net. But the question is that net appropriate for the activities and the behaviors that we've seen in this past year? And so I think that those are things to think about. And so I want to go to section, I think it's sub 5. It's where the provisions of the sections, it says it does not apply. And then it says a transaction for the sale or rental of a good or service which occurs wholly outside of the state, or the person who does not control the location or price at which a good or service is sold or rented. This I have a couple of questions here. Number one, goods are sold wholly outside of the state, but we have technically a nexus or a relationship because of long arm statute, right? And so this clearly is internet, right? To me, I read it as internet. And so I wonder why was that exclusion in play? And then how do you determine control and location? Because those things are very different. So during the pandemic, right, I wanted to buy hot oil treatment, and for whatever reason, it was $56. I'm not interested in paying that, right? But it happened, and it happened on an internet website. And so what I'm trying to figure out is, did you exclude because you didn't know how to deal with this internet sales?
Senator Mark Berger, for the record. No, we did not exclude because of that reason. We actually excluded these two provisions based upon interpretation of other price gouging statutes in other states by federal courts. There was a lot of litigation that evolved after the price gouging, regarding price gouging statutes in other states. That litigation gave us guidance to say what we should include and what we shouldn't include based upon interstate commerce and other reasons.
And so I asked because it seems like you're trying to capture folks who are business entities. And so knowing that internet sellers are paying taxes in the state of Nevada, and we have passed bills that make them equal to brick and mortar, I think that this is interesting to me, that you exclude them when they are becoming a dominant force in selling goods. And opportunities to sell at a higher rate, or have a seller on their platform sell, there is a control factor there, and they seem to be excluded, where just the brick and mortar folks seem to be locked into this bill. And that's how I read it. And I don't understand that if the internet sellers are now taxpayers in the state of Nevada.
And Mark Berger, for the record, Senator, the language of the bill is intended to capture internet sales, what that are done and consummated within the state. Those particular exclusions are for those types of transactions that occur hopefully outside of the state. So we saw a few of those in the complaints that came through, and those are the ones that were addressed by these federal decisions.
Okay. Okay. I hear you, but I feel like that definition of wholly outside of the state is very broad, because I think that there are sellers that have a relationship but they're wholly outside of the state, and but we can leave that for another day. The section on, it's B sub 3, which is on page 5 of the bill, lines 29 through 35. This is the part where it says if a person did not sell or rent or offer to sell or rent a good or service in an emergency within the 30 days. And so this is in that usual price where you're doing a comparison here. And my question is, who is doing the comparison on whether or not the usual price occurred within that time frame and now this is in excess? You have staff who is going to be designated to be looking at these comparisons and then doling out the penalties? How does this mechanically work within the AG's office?
Thank you, Senator Marker, for the record. So this particular provision looks at where there wasn't a sale of a particular item or service in a 30-day look-back period. So if there wasn't a sale, then you have to figure out a way to determine that price, and that's what this provision does. As far as the mechanics of it all, yes, that's what we did during the pandemic, in the initial time frame when we received these complaints. We worked with these companies to determine whether or not it was a supply chain increase or whether or not it was a price gouging when we got a complaint. And we did a very neutral and fair look at these things. And for the most part, we had very good reception and cooperation in the state.
And so, and thank you for that answer, because you say supply chain, and I think this is kind of stepping into what Senator Settlemeyer was saying, but typically you can have a business who there is an increase on a good because it's popular. So you're saying that if you have an increase on a good that is popular, but it happens to fall within the pandemic, you then come under scrutiny depending on the range of that cost. And I guess since you guys had this conversation during the pandemic, how did you judge whether or not that cost increase was appropriate based on the business decision of the company? Or in this case, it could have been the store manager, right? And so what did those conversations, what were they like when you started to examine true change versus excess and price gouging? Because I think that there is a distinction there. And I think that when you have language, you need to make the distinction between a business model choice of a popular item that you're saying, oh, this is flying off the shelves and I would like to charge $17 versus $15, and I'm now charging $50 for something that was $15. Do you see what I'm asking you, the nuance?
Absolutely, Senator. And the answer is actually twofold. First, we did look back and worked with businesses. It involved looking at spreadsheets and saying, this is what I paid, this is what I paid, this is a reasonable increase, or this is what the supply chain increase was and why I passed this cost on to the consumer. That's the first question. The second piece of this, and I have to keep reminding myself sometimes as well, but this is tied to a pandemic. Not only is it tied to the pandemic, it's tied to the geographic area, location of it, and the impact. So you have a fear level, right? It also includes only those consumers, goods, or services that are bought or rendered primarily for personal, family, or household purposes, medical supplies and service used for the cure, care, and mitigation, treatment, and prevention of any illness or disease, and services related to the repair and reconstruction of property or any other goods, service that are commonly used in responding to the type of emergency. These provisions are limiting in nature. And so you may have a popular item that could go up, let's say a toy around the holidays, that goes up in price. This wouldn't apply to it. It's not a necessity. It's not something that's related to the emergency. So those types of sales could continue and go up. If the regular price of lumber, for example, or drywall or a good for a tractor goes up, but it's not related to the emergency, it's not even captured within this bill. So those are the types of things that I think need to be reminded. And as I said, I remind myself about this all the time because the bill attempted to be very cognizant of all of these concerns.
Thank you for that. And so I'll move to a different section on section 5, because this is the part around minors, which I thought was super interesting. And this is new language around, and so, well, there's a couple of things, because I was happy and then I was weirded out. So the thing is, in section 5, line 14, where we have this, well, first of all, it's a civil or criminal penalty, and then you impose a civil penalty of not more than $12,500 for each violation. And so, a couple of things: who are we going after? Because there are situations, and I think everybody experiences their first year of college, when somebody went out and tried to give you a credit card, and they had a pack of M&Ms with it, and you were like, hey, I want the M&Ms because I'm hungry and I'm a college student, and then you sign on the dotted line for a credit card that you couldn't pay for. The question is, are they in?
So, Mark Kruger for the record, Senator, what we're doing is trying to capture those types of deceptive trade practices that occur for minors in the same manner that it goes after seniors or the elderly, as existing statute provides. And I'd like to draw your attention to the actual litigation that we've charged, where we've alleged that certain manufacturers of pharmaceutical products had targeted seniors and elderly people in offenses of the chapter. So it would also allow us to capture those same offenses against minors.
And thank you for that, because I guess immediately when I thought about the section, number one, contract law doesn't allow a minor to contract, right? So there's that remedy already on top. It's been around for a while. And then I wanted to know about because I felt these parts were subjective in sub E, where if the conduct of the person caused the minor person to suffer, right? And then you have this mental and emotional anguish. And I'm trying to figure out, okay, you have if a court or the director or his or her designee finds, etc., is the court making the determination of mental or emotional anguish? Who is making that determination, number one? And then when you say loss of property that had been set aside for educational or for personal family care and maintenance, that's subjective to me. And so I'm really trying to understand how you're making this determination for a loss for education or personal family care that's applied to a minor.
Mark Kruger for the record. Good questions. To answer your question, the court would make the determination. We would bring a cause of action. We would assert this based upon the facts and the evidence that we found during any particular investigation. After making that determination, we would assert and prove up these particular pieces of it. But ultimately, the court would be the one who would have to decide based upon the facts and circumstances of each case.
And how do you prove up economic well-being? Any other interference with the economic well-being of a minor person? I mean, these are not situations where, somebody took my lunch money. These are situations where I'm trying to see a 17-year-old or my kid who happens to be special, where he's saying, I thought that these people were legitimate and I gave them, $500 and I thought I was going to get a PS5 and I ended up getting a bag of rocks. The question is that an interference with his economic well-being because he had wanted a PS5 for like 6 months and then he finally got the opportunity and then he got swindled?
Senator Mark Kruger for the record, and I appreciate your example of an individual item and a potential deceptive act on an individual basis. However, you could apply any factual situation in something like, for example, in one of these very popular video games where you could take advantage of a minor by advertising you can get certain credits, but then not giving them the credits, and the minor is purchasing and being deceived about it from an economic standpoint. So there's a lot of other examples that you could throw into this that would show that be able to be proved up under this particular provision. And it just depends on the facts and circumstances of each case as we allege them in building our investigation and conducting our investigation and building our case.
Okay, thank you for that. I just think it's an interesting provision because you have damages tied to it, and I feel like you've created a new tort remedy. And it's hard to prove mental distress. And so now you have interference with economic well-being, and I didn't see the definition of that. And if it is defined currently in statute, then I'd be very interested to understand how it works and the thresholds and how we prove that, right? When we go through school, we learn that, mental anguish, there are certain circumstances that are tied to you being able to prove up that anguish, right? Being able to prove up certain things. And when you talk about emotional interference, it's so subjective. And so I'm wondering, what are the circumstantial factors that you expect to see? Because you're saying that you would be in the position to prove these things up in court and then establish that this minor was affected and these series of items occurred to them, and then assess damages to a person for the act or the effect on them. You see what I'm saying? Like, I want to see your first court case because it's going to be interesting. You need to just dial me up. Sorry, Madam Chair. I have one last question and then I'm done. So it was on the no time limit. You don't have a statute of limitations. This was in section 25. And so I wanted to know how, because it says, it's section 3, 3.5, and 5 of this act. So that includes the minor, and then it includes the other parts that the rest of the committee members were asking about. So you don't have a limitation on this action. So someone could bring this action October of 2022 and then allege something that happened this month. And so I need to understand how that works, and how does a person factually prove up an incident that may have happened today and then walk backwards? Is this retroactive?
Senator Mark Kruger, for the record, it's not retroactive. It would be prospective in application. However, this is important for our multi-state work, and several states have adopted this similar language where we leave the statute of limitations for private right of action, for criminal action conduct, for administrative actions, currently where they are at 4 years. But this particular provision is our multi-state work. It is the big heavy-duty litigations and investigations that really take a peek back in a lot of time to be able to see whether or not a particular conduct had been occurring for a longer period of time and make sure that we cover that period of time. There's been quite a few investigations that are conducted over a longer period of time as well. And the investigations themselves take sometimes very many years to be able to conclude. So it really is heavily focused on the Attorney General's multi-state investigation type practices. And
I mean, Madam Chair, thank you for your indulgence on a really weird Thursday morning. I've had a lot of analogies, and if you would like to ask a question on Section 31, then you would take care of my very last question that I was going to save for any other day. But I turn it over to you. For real, though? Okay, so in Section 31, you have the consumer advocate piece, where they have access to all records in the possession of any agency, board, or commission of the state that he or she determines are necessary for the exercise of powers in subsection 1. So subsection 1, it's super broad power. So I really need you to help understand, because I feel like there should be limitations on this for a consumer advocate, because you don't know what those records are and who is the oversight person over the consumer advocate, who's kind of the watchdog to say that I think what you're determining are necessary may not be within the legal scope of what you probably can have, because you're pretty much giving them plenary power, right, to then go in and dig and then have access to records.
Senator Mark Kruger, for the record, and let me, I think give you some comfort here. This provision is specifically included because we, as the consumer advocate and the Attorney General, have parens patriae authority to bring causes of action in support of protecting the public and consumers, right? Residents of the state. So when we do so, we are able to assert claims on behalf of any other agency, board, or commission. And we've done that in litigation we are currently litigating. So when we do assert claims on behalf of these other boards or commissions, we have to, through the discovery process, collect data from the boards or commissions. And this would ensure that they are cooperative in giving us the data which belongs to the state. And since we're asserting the claims on behalf of the state, we would be able to then provide them to the discovery process. The caveat here is that nowhere in this process does it at anywhere take away the confidentiality provisions that would apply in any portion of this all the way. And everything that we gain through an investigation remains statutorily confidential. So any kind of even privileges or statutory authority to keep things confidential would always be retained. But it is absolutely a necessary component to ensure the smooth litigation of claims on behalf of the state for this provision to be in the bill.
Thank you, Madam Chair.
Are you sure? Additional questions, Senator Hardy.
Thank you, Madam Chair. Reading the book, or the law, I'm looking at undefined words: grossly, generally available, unconscionable, unfairly, arbitrarily. All of those words denote that if I could use Senator Sentelmeyer's privilege of naming people, if I buy something at Walmart and I go to Neiman Marcus, I think it's unfair. So that the arbitrary nature of the words are concerning to me. And then one of the other challenges we have is in political seasons, we have politicians who promise things and then, on a robocall, for instance, and then they don't, and then the person has to pay more property tax and they lose their home, and so now they have had unconscionable, arbitrary, grossly in excess of a price, a service, a political service, as it were. So I suspect you're not trying to get politicians who promise the sun and the person only gets a star.
Senator Mark Kruger for the record. To your point about unfair, this is the Nevada Unfair and Deceptive Trade Practices Acts we're talking about. So the term unfair, while your point is well taken, these terms weren't even included in the law. So including them in the law and allowing it helps us to capture those types of transactions that are particularly offensive and would categorically fall within that language. There is a level of discretion in prosecutorial discretion that when you look at this to find out, okay, does this fall in the meaning of it? Just like other areas of the law have that. And I'll give you an example. It helps to capture things like where you have notarial fraud, where an individual is using a different language to perpetrate and say, hey, I'm able to do these services, when really they're not able to do their services, and they unfairly take advantage of that individual. So that's the type of thing flex. As to your comment about the politicians, no, it would not apply. The politicians are not in the business of selling a good or service. So they have their own protections, and this certainly doesn't apply to them.
Thank you. I'm still trying to tell my kids what fair and unfair means. Thanks.
Senator Pickard.
Thank you, Madam Chair, for the second opportunity. Just one question. It's a follow-up on something that both Senators Neal and Settelmeyer were getting at, and this is something I didn't see before, but I think it's a good point that I'd like to see if we can clear up on the record. when we talk about and I'm looking at section 1, or I'm sorry, section 3, sub 3, where we're talking about, sub 2, where we're talking about price that is grossly in excess of a usual price. And then you had mentioned the 30-day look back. It occurred to me on second reading that this seems to, although it says including without limitation the price of the good or service prevailing in the emergency or disaster area in the 30 days before, and then we overlap the fact patterns that they were suggesting. My first read on this was that that's unlimited. That's one of the circumstances, but this would be where we could assume or read into it that that's one of many conditions that we would look at, and the other conditions would be the supply chain effects, the costs of the component parts of these things. But I think we might want to make that stronger. I think we want to make that clearer, because this discussion brought up the fact that some people are not going to read it that way. And if this is a criminal action, that's going to be up to a jury. And the jury instructions will have a great deal of influence on that. But I'm assuming well, first, is that the assumption that was my first reading what you were talking about when you said there's a provision that would allow for supply chain reactions that wouldn't then make them violative of this act? And if that's true, given the apparent ambiguity, is there room for, in this, not appeal, the amendment that you had suggested is out there, but it's not online, would there be room to make this clear in that instance, in this subparagraph?
Senator Mark Ruger for the record. Yeah, we already did several amendments to this bill, so we don't have another amendment out there. But you're correct in that this provision is supposed to limit the amount of time you can look back. So you don't have to look back like 60 days and say, oh, wait, you're price gouging within the constraints of this bill. If you look back on the 30-day period, we thought it was a reasonable period to see, okay, this is the usual price that's being sold. We didn't find that there was any confusion, but I'm trying to clear it up if there is any, that it does not include the supply chain. And this is one of those factors that go to that, so that if there is regular normal supply chain increase, those can be passed on.
All right, I appreciate that. And one thing we have seen in lumber is that we've seen significant, 100% increases within a 30-day time period. And the local manufacturer would have no way of recouping that cost if we were limited to a 30-day look back. So I would suggest and request that we tighten this language up to make sure that it's clear that supply chain impacts are not intended to be included in the definition of gouging. But that's it. Thank you, Madam Chair.
Additional questions? Okay, I just have a couple, and then I'd like for Mr. Keene to weigh in on some of the opportunities we may have for clarification for some of the questions that have taken place. And I'm thinking here, back in 2005, I think it was Hurricane Katrina, and I have some family members that are in Houston. Before they announced the hurricane hadn't hit, but before they announced the hurricane was coming, I think my sister said it was like $2 gas was $2 a gallon, and within 20 minutes of announcing, the gas was over $5 in some areas, and you had people that were lined up trying to get out of the eye of the storm. So that's one of the things when I think about price gouging. That's one of the things that I think about. And then I guess to go to Vice Chair Neal said it's difficult to prove mental anguish when you're trying to put it into law. And I think we could probably get a real good definition of that if everybody shows up again on Friday and starts recording. And you'll see mental anguish. So So, just a joke. I think. Was that a good joke? Okay. All right. Mr. King, can you do a point of clarification here? And what I'm going to ask everybody to do is, we're running out of time here, and so I'd like for Mr. King to work with those of you who had some questions or issues, and let's see if we can hammer them out today if possible. But Mr. King, can you clarify some of the points that were raised?
Thank you, Chair Spearman. For the record, Will King, Committee Counsel. One of the things that occurred to me as I was listening to the discussions was that in Section 3, and in particular, Section 3, it's page 4, line 22. It's the beginning of subsection 3. The language there is written in the negative, which makes it a little bit difficult to read if you're reading it quickly. So what subsection 3 does is it tells you when a price for a good or service is not grossly in excess of the usual price. So if you are someone who's selling a good and you can show that your price falls into any of the delineated circumstances, 3A, 3B, 3C, 3D, you don't have to qualify for all of them. You just have to qualify for any one. And then your price is not grossly in excess, so you are not in violation of this section. And one particular point was brought up a lot was the supply chain issue. I don't know about any particular business and its supply chain circumstance, but if there's a particular price of plywood and it's being sold by the retailer at an extra high cost because that's what it costs the retailer to buy it, then if I were trying to defend that retailer who's accused of violating this, I would look to subsection 3, paragraph C. And that's where it says that if the retailer is charging 10% or less above the sum of the cost to the person and the normal markup for a good or service. So if it was costing $500 for a sheet of plywood for the person to purchase, and then they sold it for, my math is not that sharp, but say $505, even if $505 is a ridiculously high price for a piece of plywood, that seller would not be in violation of this section. And there's a number of other provisions, all of which address other circumstances which may arise for a particular seller. And all the seller has to do is make sure that the seller is falling into one of those categories, and then the seller is okay. That was just a small point on that, and I can certainly, I will reach out to people and work on concerns about tightening up this language on top of it. But I just thought I would point that out to the extent that that wasn't clear in the previous conversation. And then as far as section 5, subsection 2E, some of those terms are, are subjective, but many of them appear in the law, such as emotional anguish. Those type of terms appear in other circumstances, and the courts have tests that they put together. And I would say on top of that, for all of these sections that we're putting in, and for all of Chapter 598, the Director of B&I, as well as the Commissioner of Consumer Affairs, which I believe right now pursuant to statute is a Deputy Director designated by the Director of B&I, they have ample reg authority, and there are regulations carrying out some of these provisions. And so to the extent that any of these items need to be fleshed out or described in more detail, that can always be done through regulation. That's not to say we can't fix it here and do it in this bill, and I will certainly reach out to people on that. Thank you, Madam Chair.
All right, thank you. No additional questions? Senator Hardy?
Thank you, Madam Chair. I'm just thinking out loud now. It may not be the case, but the reality is when you have a inventory of plywood and you then sell it at a grossly elevated price, you then have to understand that your inventory has to be replaced. And the inventory that has to be replaced is probably going to be at a grossly elevated price because the supplier or the wholesaler is going to have to or will charge more for the renewal of your inventory. So your business has to pay more, charge more in order to be able to get their inventory back up to speed so they can sell again. So And I just think that that's probably one of the things that just because you have it, you've paid something for it, doesn't mean you're going to be able to replace it. Replace your inventory at that same price. Thank you.
Okay, thank you. And I guess to your point, this was maybe about April, May last year when there's no Lysol on the shelves and hand sanitizers, and I ordered some online, and the Lysol, the can of Lysol was like $4.50, but the handling charge was $10. So it's like, what do you do? Yeah, so anyway. Any additional questions? Alrighty. So seeing no additional questions from the committee, let's see if anyone here in the room is in support of Assembly Bill 61.
Morning, Madam Chair, members of the committee. Edith Duarte, E-D-I-T-H, D-U-A-R-T-E, with Strategies 360, today representing eBay. I'd like to register the support of AB 61. eBay, during the early days of the pandemic, worked with the AG's office to ensure that price gouging listings were removed and prohibited from being on the site. eBay has a zero tolerance for price gouging on their marketplace. And since early February 2020, they've prohibited products marketed with the term coronavirus, which violated their policies against making unsubstantiated health claims. We look forward to working with the AG's office and the Office of Consumer Protection.
Thank you. Anyone else in the room support? Okay, broadcast, let's go to the phones, and we'll do 15 minutes per and 2 minutes per individual, starting with those in support.
Thank you. Good morning, Chair. If you would like to testify in support of AB 61, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 61, please press star 9 now. Chair, you have no callers in support at this time.
And let's go to opposition.
If you would like to testify in opposition of AB 61, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 700, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and members of the Senate Committee on Commerce and Labor. My name is Brian Wachter, B-R-Y-A-N-W-A-C-H-T-E-R, on behalf of the Retail Association of Nevada. We appreciate the ongoing conversations that we had with the Attorney General's office, but unfortunately, we disagree with the policy, and we have concerns. Most emergencies don't last 75 days, so the provision that limits this to 75 days would only apply to these extreme situations. We do agree that there is ambiguity as to what is applied to, and we strongly believe that Section 3, Sub 1A encompasses every single product. And so we are talking about 500 million SKUs. And while we appreciate the ability for retailers to be able to prove that it wasn't price gouging in later subsections in 3, what this is going to do is increase the cost of compliance for a business to have to be able to prove on every single price increase, on every single item, that there was a reason for that price increase. And we believe that that cost is not in proportion to the hearing or to the testimony that we heard in the assembly side, that the Attorney General's office had received dozens of complaints since the beginning of the pandemic in March to February. And we believe that this is kind of an overreaction to those issues, that is not a sufficient sample that would give us any direction to be able to go. And I want to say how proud I are of our retailers and our clerks who during the beginning of the pandemic saw great changes to the supply chain. We are currently seeing huge challenges in the supply chain. These are ongoing issues. That first weekend of the pandemic in March, we saw the entire foot traffic that we would normally see during a Christmas season during 4 days. It's chaotic, and for a business to have to go ahead and have to report and comply and being able to prove why their prices are increased for such a long period of time, we must register our opposition to the bill, and we would ask you to do so as well. Thank you, ma'am.
Chair, you have no more callers in opposition at this time.
Let us go to neutral.
If you would like to testify neutral on AB 61, please press star 9 now to take your place in the queue. Again, if you would like to testify neutral on AB 61, please press star 9 now. Chair, you have no callers neutral at this time.
Okay, thank you. Committee members, additional questions, comments? Mr. King, do you have a comment?
Yes, thank you, Chair Spearman. I just wanted to respond to Senator Hardy. I think Senator Hardy raises an excellent point about inventory that might have cost something in the past, and the replacing of that inventory would cost a lot more. And that's not addressed by Section 3, subsection 3C. One can make an argument it might be addressed by 3A or 3E, but it's not exactly expressed there. And certainly, to the extent that, as the chair was saying, that we could tighten up the language, something like the replacement cost of inventory could be added to 3C, and that's something that we could definitely explore.
Senator Hardy? Okay, all right. Okay, seeing none. Mr. Kruger, do you have any closing comments?
Just briefly, Mark Kruger for the record. Thank you, Chair. While we're disappointed with opposition today, we worked with the stakeholders in good faith, and we did make significant concessions to address all the concerns. The idea of tying the price gouging effect to a declaration of emergency gave a trigger point. It may not be a perfect solution, but it is definitely a good solution. And it is one that is reasonable in light of the intent. And the intent, again, is that this only lasts as long as the emergency lasts. It doesn't affect the supply chain. And it's intended to address those sellers of goods and services who would take advantage of people's desperation during an emergency. That desperate need to get critical things that are necessary to address the emergency. And that's what it does. And as Mr. Keene also pointed out, it does provide those exceptions for those supply chain examples that we talked extensively about today. I thank every member of this committee for your wonderful questions and the engaging conversation. We appreciate it and look forward to your support on the bill. Thank you.
Thank you. And I've asked, as I said before, I've asked our legal counsel to work with the questions, those persons who had questions, and with you, Mr. Kruger. Let's see if we can get some language that works and addresses the, I think it was Mr. Walker that says like 500 million SKUs. Let's see how we can maybe tighten that up. We only have tomorrow. So if we can get something done today, I certainly would appreciate it. I'd like to move the bill, okay? Okie dokie.
Thank you very much, Mr. King.
Okay, and with that, we will close the hearing on AB 61. We have no more bills to hear today, but I understand that we have another one coming. So broadcast, let's go to public comment.
Thank you, Chair. If you would like to speak in public comment, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to speak in public comment at this time.
Okay. Thank you. And with that, we will not adjourn, but we will be in recess until the call of the chair. Thank you so much. Hi, we are back from recess now, and we are ready to adjourn. And so we will adjourn this meeting of the Senate Commerce and Labor Committee for Thursday. We are now adjourned.